Peace and blessings. This is another mortgage checkup, and in this video we're going to go through and talk about how homeowners, how we give up power of attorney and we consent to foreclosure. Yep, I said it. It's in the contract, and this is your mortgage contract, your security deed, trust deed, or mortgage contract. Just depends on the state that you're in. And just going through all of this and researching for a while now, my sentiment would be, in order to have full disclosure at closing of a mortgage contract, it should take no less than 30 days for that new homeowner to actually go through and read and absorb the contract that they're signing. However, what typically takes place is a closing may take, 2 or 3 hours max. So anyway, let's look at this. This is where, again, you see here, where you give up power of attorney and consent to your property being stolen from you. This is actually a security deed, and in the section here 22 where it says acceleration and remedies. Now this section that I have highlighted, this is what we're going to read. Lender shall convey to the purchaser indefeasible title to the property, and borrower hereby appoints lender, borrower's agent, and attorney in fact to make such conveyance. So you the borrower, you appointed the lender to be your agent and your attorney in fact. Go look in Black's Law and look up attorney in fact. Basically, you are granting and appointing the lender to do, quite frankly, whatever the heck they want to do. The recitals in the lender's deed shall be prima facie evidence of the truth of the statements made therein. Look up the word shall in Black's Law. Borrower covenants and agrees that lender shall apply the proceeds of the sale in the following order. A, to all expenses of the sale, including but not limited to reasonable attorney's fees. B, to all sums secured by this security instrument. And C, any excess to the person or persons legally entitled to it. The power and agency granted are coupled with an interest, are irrevocable by death or otherwise, and are cumulative to the remedies for collection of debt as provided by applicable law. Now these jokesters, they went as far as to say that you cannot revoke the appointment that you had just granted to the lender, as far as them being your agent and your attorney in fact, even by death. That's what this contract says. Then the last paragraph, and I'm going to share a remedy, of course, to change this up. The last portion, if the property is sold pursuant to this section 22, borrower or any person holding possession of the property through borrower shall immediately surrender possession of the property to the purchaser at the sale. If possession is not surrendered, borrower or such person shall be a tenant holding over and may be dispossessed in accordance with applicable law. I want to go back and read this last sentence. The power and agency granted are coupled with an interest, are irrevocable by death or otherwise, and are cumulative to the remedies for collection of debt as provided by applicable law. Wow. Was this disclosed to you at closing? Did they make you aware that not only were you granting or appointing your lender as your agent, but your attorney in fact, to make any such conveyance? Now, this is not only just talking about assigning it to another lender or conveying it to another lender, but it's also talking about when they get ready to foreclose on you for default within the contract. So basically, you've given a power of attorney away, and you can rescind that power of attorney if you go through and you recognize the fraud that is taking place. And any point where fraud has taken place, it nullifies the entire agreement or the entire contract. So full disclosure is, it's really a biggie, which it never happens. You're never, given all the details of this contract, because if we were, probably no one would buy homes in the traditional sense. We just wouldn't do it. So anyway, there's another portion here. If this didn't do it enough in the contract, there's even another document, and the document is titled Waiver of Borrower's Rights with an S. Okay. By execution of this paragraph, grantor, that's you, expressly, number 1, acknowledges the right to accelerate the debt and the power of attorney given herein to lender to sell the premises by non-judicial foreclosure. This is in a non-judicial state. Upon default by grantor without any notice other than such notice as is required to be given under the provision of the paragraph 22 hereof. 2. Waives any and all rights which grantor may have under the 5th and 14th Amendments to the Constitution of the United States, the various provisions of the Constitution for the several states, or by reason of any other applicable law to notice and to judicial hearing prior to the exercise by lender of any right or remedy herein provided to lender, except such notice as is specifically required to be provided in paragraph 22 hereof. 3. Acknowledges that grantor has read this deed and specifically this paragraph and paragraph 22 of this deed, and any and all questions regarding legal effect of said deed and its provisions have been explained fully to grantor, has been afforded an opportunity to consult with counsel or grantor's choice prior to executing this deed. This is straight bullshit. Sorry. Number 4, acknowledges that all waivers of the aforesaid rights of grantor have been made knowingly, intentionally, and willingly by grantor as part of a bargained for loan transaction. And 5, agrees that the provisions hereof are incorporated into and made a part of the security deed. OCGA section 7-1-1014-3 requires that we inform you that if you fail to meet any condition or term of the documents that you sign in connection with obtaining a mortgage loan, you may lose the property that serves as collateral for the mortgage loan through foreclosure, read and agreed by grantor. Now, I don't remember any of this. Of course, it's commonly known that in a non-judicial state that foreclosures could possibly happen a lot quicker than in a judicial state, because you have pretty much signed away rights to a trial by jury. However, any contract that we go into, it cannot be in direct conflict with the supreme law of the land, which is the Constitution. So even though here in section 2, where it says waives any and all rights which grantor may have under the 5th and 14th Amendments to the Constitution of the United States, that's a nullity. It cannot happen. In fact, there is a Supreme Court case, and I would encourage you to Google it and read it. It's Brady versus the United States, and I have it here in front of me, 397 U.S., 742 at 748. And I quote, "Waivers of constitutional rights must not only be done voluntarily." Okay, so we signed. So, okay, it was voluntarily because we signed it, right? But they must be knowingly intelligent acts done with sufficient awareness of the relevant circumstances and consequences. So not only must you voluntarily waive your constitutional rights, but you must, this is according to Brady versus U.S. Supreme Court case, but you also must do it knowingly and intelligently with sufficient awareness of the relevant circumstances and consequences. So these two documents right here by themselves are fraud, because there was not full disclosure. And who in their right mind would sign something like this? Something for you to ponder. Anyways, I will see you in the next video. I'm actually going to do a follow-up video on this. So check the channel here. I'll see you in the next video. Take care. Peace and blessings.